The cross-examination of the alleged intruder wraps up week 3. Hello and welcome to Inside the Courtroom, the Senzo Meyiwa trial rep. I'm Linda Mnisi. An absolute pleasure to have you with us. We're coming to you from our Randwick studios in Johannesburg. And as always, you know by now, our viewer question for the week. And this week we're asking whether it's become necessary for Bongani Ntanzi to call an expert witness. Those options are on your screen. Yes, no, doing just fine, or the ship has sailed. This is a poll that we are running through our social media platforms, so make sure that you go and you vote there. All right, let's get to it. The court could not sit on Monday due to a power outage, but returned on Tuesday with the state picking up on the photographic evidence. Take a look.
On the 12th of November 2020, there was a certain activity on your phone. In fact, a number of activities that we wish to take you through at this point in time.
Kukhona ke nje okuhlukahlukene kwakwenzeka ke kumakhalekhukhwini wakho esifisa ukuthi sikukhombise kona ke njengamanje. And in this regard, we wish to refer to page 2378 of 5471, Exhibit 6, the extraction from your memory card. There's a picture. You see that? Page 2378. Of 5471, Exhibit 6. Can you identify the person on the photo?
Lapha simnyama kodwa ngoba isithombe engeke ngasibona ecourt. Isithombe ngesama isithombe engeke ngasibona ecourt, but lapha simnyama.
It's dark here, but because it's a photo that I've seen in court, it's my photo, but it's dark here.
When we look at the metadata, it says file name, carved raw. And we've been through that terminology as explained by Warrant Officer Ndlovu. Carved raw means the photo was deleted.
Kubhaliwe ke laphayana ke igama ke layo ifile noma ke file carved raw ngokusho kwakhe ke yena uKenya Ndlovu ke ukuthi ke isithombe sasi suliwe.
Cha ngivumi futhi ngiyanqaba.
No, I disagree.
What are you disagreeing with?
Yini oyinqabayo?
Ungavumelana ukuthi isithombe lesasidelete. Bese ithombe ikhona efonini yami.
That this photo was deleted. These photos are there in my phone.
As always, we have guests to help us unpack this week's evidence. Itumu Gwena is in studio with me. As you know by now, she is a commentator who religiously follows the case. Via Zoom link, we do have Melusi Xulu as well as Bongseni Gunene, who are both legal analysts to help us navigate the legal aspects of these proceedings. Thank you very much for joining me. I'll start here in studio. Itu, I want to just get an overview of, you know, the evidence this week. Last week we spoke about maybe how fatigued people are with cell phone evidence. Are you fatigued?
No, not at all. I feel Advocate Baloyi keeps bringing new aspects of the evidence that he has led, specifically the cell phone evidence, the towers, and the photos. Yes, we have gone through this information, but I feel like this week he was putting it into play and showing us the picture. He was telling us that, you know, this is the first call that came in. Why did it come from that person? Where did they get the numbers from? So he was being specific and intentional with the evidence that he has already laid, which was quite impressive for me. I'm still impressed. I'm not bored. I still want more.
All right, let's go to Sibongiseni. Sibongiseni, you are also a legal analyst that follows this case religiously. I mean, Itu and I are just reflecting on how there seems to be fatigue on this particular aspect aspect of the evidence, particularly because it deals with one specific, or one would say multiple aspects, but ultimately it will draw down to whether or not Bongani Ntanzi had his phone while he was in custody and the link thereof to Ntokozo Mjiako. Let's talk about your view when it comes to this evidence.
Yeah, there is a level of fatigue on it because I was under the impression that it's not going to surface this week because seemingly then the point was already made by the state. And so I don't know why then they keep on going to it. But nonetheless, seemingly then now they are moving to other topic, which is the affidavit from bail application.
Yeah, let's move to you, Melusi Xulu, and I want us to talk about, the technicalities. I mean, we're hearing craft raw deleted images, and these sound like, technical aspects that a layman may not necessarily have full grasp of. And you would have seen our viewer question today is, has it become necessary for Bongani Ntanzi at this point to consider calling an expert witness?
Hi, Linda, and to my fellow panelists. Look, what I think is important is whenever it becomes issues that are technical and those that need expertise, as a defendant, to a certain point, you do need an expert witness that can assist you. But we've come to this point before, and we know how expensive it can be to get an expert witness. So that is another challenge that is there.
I was asking Melusi about the aspect of technical evidence and the need, perhaps, if there is any, for Bongani Ntanzi to call an expert witness.
Yes, I heard him. I think he was explaining that evidence in its technicality, in its nature, then warrants that somebody can bring an expert to come and counter such an evidence which was given by the expert at the time when it was led. So in this regard, Ntanzi keep on saying that, okay, this picture was taken on this day and I was not in possession of the phone. This caller could not make this call because I was in custody thereof. So for that evidence maybe to stand in contradicting that one of the state, because the state, they are alleging that there could be no any other person other than you who could be taking these pictures, making these calls. So you need just to bring an expert to come and testify about the metadata. If then there's anything that has been freaked or maybe interfered with the metadata, then the expert, if from his side, if he can come and say, yes, this metadata is something it does not speak to the raw material as to when the picture was taken, and it simply speaks about this, collaborating his evidence, because he's the one who says this. I remember this picture, I took it on this day, and then him alone without an expert coming to confirm such evidence, because in its nature it's scientific, then it won't be that strong, and not unless maybe there could be any other witnesses confirming that indeed on this day I'm the one who took the picture and I'm the one who was with Ntanzi, as he alleges that there's somebody from Mukhozi FM and also a gentleman who is from his villages. So I think an expert will be necessary for him to rebut the evidence of the state.
Yeah. Let me come back to Studio Itu. Do you think there's anything to be said about the manner in which Bongani Ntanzi answers, these questions? One may argue that it sounds a bit evasive and argumentative, but others may look at it from a different perspective, saying he's tackling the evidence head on.
Yeah, I mean, you see, it's very argumentative, it's very evasive, he's not answering questions. He reminds me of, I know you followed the Rosemary case. He literally reminds me of Rosemary on the stand. He doesn't want to answer questions, he denies a lot, and the denial is very impossible, you can't deny things like that. Also his tone as well, he's very aggressive on the stand, no sense of remorse or anything. Well, I guess in his case he says I didn't do it, but the way he is addressing these questions, the way he sounds, the way he's arguing with Baloyi, and I think this week Baloyi was like, do you want me to print out the transcript for you? And he said, well, it's up to you. whether you want to do it or not. And as I said, you know, the state is quite prepared. They were sitting there with the printer and they printed it out for him, and he had nothing to say after that, you know. So I think I don't know if he's ill-advised or what, but he is not, I don't think he's helping himself in the way he's answering these questions.
We seem to have re-established that line with Melusi Kulu. Melusi, I want to come back to you. Itu was just talking to us now about the manner in which Bongani Ntanzi answers questions. What do you make of it? Because what I put to it is whether or not you think there's a level of evasiveness and being argumentative, but others may see it as just him tackling what is being put to him head on and really being steadfast in, you know, his evidence.
Well, there's a very fine line between arrogance and being confident of what you are presenting as an accused or as a defendant. So I think he must be careful of not really being a person who's fighting against the prosecutor, who's cross-examining him, Advocate Baloyi, because at times he might be answering, you know, with a mindset that he's angry about how he's being asked questions. But then he will come out as being a person who's very robust and arrogant. So I think that is important, because the manner in which you answer questions when you are being cross-examined is very important. And you mustn't be evasive. You must answer in a proper manner, because you are there to present your case. That is why sometimes, if possible, not if possible, but it's very important to, you know, that your legal practitioner practices these questions and helps you with your mindset to be ready to answer, because it can come out as arrogant, and that will ultimately make your case to be difficult.
Sibongiseni, it raises a question of remorse. And, you know, I've covered so many cases where this issue of remorse has been debated. You know, I've heard a counsel saying, well, you can't expect an accused person to show remorse when they've basically told the court that they didn't do it. You can't be remorseful about something that you did not do. So where do we draw the line between remorse, arrogance, and being steadfast?
Remorse is too stretch, is something else, because remorseful is being apologetic and showing that you are sorry about something that you have done, right? Then maybe the only thing that we can talk about is being respectful to the proceedings and answering questions, not just being arrogant or the demeanor, because it sometimes plays a huge role. When then the presiding officer has to arrive to a decision, the presiding officer can say, you're just too arrogant and evasive, not answering the question, only just shouting, or maybe just throwing words like stones to the prosecutor other than answering the question. I don't think maybe remorse is something else, because being remorseful, it's when somebody, we can say, is pleading guilty and apologetic and all those stuff. So remorse, I think, is something strange.
Yeah, and I want to come back to Studio Itu, the issue around the technical aspect, right? And whether or not, you know, Bongani Ntanzi should be calling an expert witness. The other week you were talking to us about how his witness list continues to increase.
Yes, I believe Baba Ntanzi needs to call an expert, especially because, you know, when it comes to the metadata, there is some metadata that he's saying he's accepting, you know, and then there's some where he says he's not accepting. So he would need to call an expert to speak to the issues that he's raising with this metadata that he's saying he's not accepting, saying that it's been edited. And he's also saying it's not been edited by Ndlovu, but it's been edited by Advocate Baloyi. So it's also, we're not sure when this editing actually happened. So he needs to bring an expert to speak to his issues. He also needs to bring his family members, because those people were on the phone with somebody on that line. We don't know who that somebody is. State version is different, his version is different. So he needs to bring his family so that they can explain who were you actually speaking to. I mean, these calls started the next day after he got arrested, and they continued. So they maintained a relationship, maintained communication in between. And it wasn't like 5 minute or 5 seconds communication each day. It was very fluctuating, you know. We were having conversations. I'm notifying you of something. Oh, I'm confiding in you. I don't know. But if you look at the data, as Ramsipile says, data is data. It's not going to lie. If you want to dispute it, bring an expert.
All right, so I want us to take a quick ad break because when we come back, we'll look at more evidence that came out from the state's cross-examination this week, so don't go anywhere. Welcome back, and thank you for choosing to stay with us. If you've just joined us, you're watching Inside the Courtroom, the Senzo Meyiwa Murder Child Rep, and I'm Linda Mnisi. Now, this past week, the state also turned once again to the issues of Bongani Ntanzi's disputed lawyer, that's Ntokozo Mjiako. Now, in case you're wondering who this Mjiako person is, he is the lawyer who allegedly represented Bongani Ntanzi when he allegedly made his second confession statement before a magistrate. Now, it's the state's case that Ntanzi implicated himself in Meyiwa's murder as one of the two alleged intruders of the Khumalo home. He did so through deposing two confession statements. Now the state has once again revisited the evidence on Mjiako. Take a look.
The question is, Mr. Ntanzi, how did you know that this Mr. Mjiako? Did he tell you that he is Mr. Mjiako?
He said he was a lawyer, he was sent by my family.
Yes, but you said you got to know that his name is Mjiako on the 25th of June 2020. How did you get to know that? Did he introduce himself as Mjiako?
When we met at the door, he told me that he was sent by my family to come and represent me, that he was a lawyer. He did not tell me on that day, the first day, that he was Mjiako. Hence, I asked him, who called you from my family to tell you or to ask you to come and represent me? Because at home, they don't know my whereabouts.
All right, I'm still joined by my guests to take us through the evidence. Idumukwena, as you know, commentator, as well as Melisi Xulu and Sibongiseni Gunene, who are legal analysts helping us with the legal aspect. Once again, I'll start with you, gentlemen. Once again, we are faced with the evidence of Ntokozo Mjiako, Bongani Ntanzi seemingly maintaining his standpoint on that particular front. And again, another aspect that one would have thought the state has traversed and put to bed. Sibongiseni?
Well, in this issue of Mjiako, if I remember very well, when these transcripts were read by Baloyi, and then Ntanzi says then, well, he never knew about the name of the guy. I think also on the same day, there is a transcript which he read coming from the trial, within a trial, wherein then he says Ntokozo then introduced himself to him as Mjiako. But nonetheless, I think the only way to deal with this issue of Mjiako, because it's seemingly to be mounted on it, because the state is bringing so many pieces of evidence trying to mount him on the Mjiako story. The best option maybe for him is just to waive the rights and then let Mjiako to come and testify so that they can challenge Mjiako story, because Ntanzi keep on asking and saying, who called him? And he does not deny that he was there. It's fine. Who instructed him? You see, those questions could be better if they could be posed to Mjiako. Then let's say Mjiako, they call him and put him on the stand. They cross-examine him. Mjiako, on this day, how did you know that I was arrested? And who called you? And who informed you about all these things? Because those questions, I think they are questions that could be posed to Mjiako, not just to the prosecutor, because the prosecutor won't answer any question. I think the best option for him to deal with the Mjiako story is to call him Mjiako and waive the right.
Yeah, let's come to you, Melusi. I mean, you hear what Sibongiseni has just said about calling Mjiako. He is, of course, after all, a competent and compellable witness, but he drills into the question about the instructions and where he would have received these instructions. I mean, talk to us about that particular aspect and the importance of Mjiako coming to court and telling the court where exactly he got these instructions from.
Yes, I think only Mjiako can answer that, or maybe his family, which is Ntanzi, can confirm if they call Mjiako or not. Because sometimes it happens, that you as an attorney will be called by the family to go and do bail for an accused the next day. I'm just making an example. And then when you come there might be another attorney who will be there, maybe sent by a friend. So it needs to be very clear by Mjiako to say, I was called by Babu Ntanzi from Wanongoma, who said I must come to court and assist his son in his cases, or one of the cases that he was part of. So only Mjiako can answer that. And I'm also interested to know from Tanzi, if he's saying nobody from his family hired Mjiyako, then Mjiyako must be clear as to who hired him to come to court. I think that's the only way we can deal with this matter, because we dealt with it at the trial, within a trial. Now it's obviously coming back again. And now I think Mjiyako can answer to that if there is a need, or if it is such an issue that it needs clarification.
Advocate Baloyi says the fact that Bongani Ntanzi said, he did not ask him his name when they met on the 24th of June 2020 is indicative of the fact that he already knew this person.
Exactly. You already knew the name. He didn't have to tell you his name again, but obviously Ntanzi is denying that, and that's when Baloyi pulled out the record from the trial within a trial. And that record is quite interesting, and Advocate Baloyi, he'll forever be famous, because he says that, okay, when Ntanzi explained the Mjiyako, we knew Mjiyako as Dominic Mjiyako. We heard of Ntokozo from Ntanzi in the trial within the trial. But then he also continues to say that Ngitume uSisi. Sisi is the one who gave me the mandate to come here. Advocate Baloyi says, let's go to your contact list. Here is a contact that says Sisi. And then Ntanzi says that, but it doesn't say Mantombi. Who's Mantombi now? Where did Mantombi come from, Ntanzi? Are you making admissions now? Because the person that sent Mjiyako was Sisi, who happens to be Mantombi and now is married. I love that evidence.
Yeah. It's interesting because, if Bongani Masuku was here with us, he would jump on and say, it does not mean the Sisi that is on Ntanzi's phone is the same Sisi that would have, instructed Mjiyako.
That's exactly what Ntanzi is saying. He's expecting to see Mantombi there as the Sisi, because Mantombi is the one that instructed. He knows who instructed, because why else are you bringing Mantombi into the picture? We're speaking about Usisi. We don't know who Sisi is from. But now you are telling us about Mantombi, who is now married, and her name should actually be there. So you know who actually sent Mjiyako.
Yeah, and I suppose, Sbongiseni, the issue of instructions can be settled by Mjiyako himself, and by providing, for example, evidence pointing to the fact that there were instructions, particularly financial instructions.
Yes, that's correct. Other than Mjiyako, then I don't think this instruction can be confirmed even by the family member, because if you remember that Ntanzi is the one who brought the issue of Sisi in this issue, and says Mjiyako, when he met Mjiyako, said he was informed by Sisi and that he must come and assist. You can't just say that maybe that sister is going to come and confirm same, because now Ntanzi seemingly is denying that. The likelihood of the sister to come and confirm that is impossible. So the best option is just to have Mjiyako and see if then there was any financial instruction, and if so, who then promised that he's going to pay him for the legal services.
Yeah, but also, Sbongiseni, what I find quite interesting is the issue around the many court appearances. We saw how it started a debate, which is something we're going to get to shortly. But, the issue around these instructions is very interesting in the sense that, there are appearances here, and it seems Bongani Ntanzi is also arguing that in certain instances, the court was told that I was sick, when in fact I was not.
Yes, there is a number of appearances, as much as I didn't hear correctly the question, but there is a number of appearances which were read from the records. If I'm not mistaken, 5 appearances that happened. So then there is a question, is it possible that you can appear 5 times without having any financial instruction? Then this is a criminal matter where most of legal practitioners, they want to secure their financial instruction as early as possible, because anything can happen. Should this person get convicted, and who is going to pay you? And then you can't recover those funds. Possibly then we need to know, from second appearance, you still appearing with a promise. Third appearance, you appear with a promise. Fourth appearance, fifth appearance, or sixth appearance, whatever it may be. Then you don't have any financial instructions. Then those questions has to be asked from the exact person, being Mr. Mjiyako, as to who indeed was paying him by that time, because Ntanzi says then he didn't have any money and stuff, and then for that reason they also apply for legal aid. We don't know how far true it is, and then we need to know the financial instructions, where do they come from?
Yeah, Melusi, the issue of, the financial instructions and Bongani's rebuttal of the fact that, those appearances were made saying that, at times court would be told that he's sick. Surely the court would have to receive a sick note of some sort. Would that be applicable? And I'm talking here as just a layperson, that if I don't show up to work, I'd need to produce a sick note or a reasonable explanation as to why I cannot be present at work.
Yes, I think that is what is normally required, because if you don't come to court, a warrant of arrest will be issued, but to be stayed over, suspended for a period of 14 days, court days. So when you come to court and you are sick, you provide a sick note from a doctor to show that the reason why he did not come to court is because you were sick. But his explanation is he was told that he states that the court was told that he's sick and he doesn't know anything about it. But what is important about this whole thing, Linda, is that once a person appears on your behalf as an accused, you either state to the court in court that I do not know this person, none of my family members have told me about this person. But once he appears on your behalf for more than 3 or 4 times, it shows that there's an acceptance and a relationship of an attorney and a client. And that is what is strange for me. That is why, if this is such an issue, I think Giaco and the proof of financial instructions, as Mr. Winene was saying, might assist in that regard to show that there was an instruction and there was a family member that instructed him. And then it will also show that, in fact, Mr. Ntanzi did know that this is his attorney. Whether he knew his name as Togos or Dominic or Mr. Mjiaki, that's another matter.
Yeah, but there's also another rebuttal of him saying, look, I tried to raise my hand and, I was not listened to. How should the court deal with that?
And in court, Linda, it would be very strange where your client picks up a hand whilst maybe you are presenting a certain presentation about the matter, and the court does not say, Mr. Kulu, your client is picking up his hand, can you please go to him and hear what he's saying? So I think that is very strange. It's not normal. Unfortunately, there's no court records that can say in the transcripts that Mr. Ntanzi picked up his hand. So it's his word against whatever is stated against him. That is why it would have been easy if maybe he would have said, whilst this proceeding were happening, said, can I speak can I speak for myself? And states that I do not know this person. But whether he picked up his hand or not, the bottom line is, for every appearance, he did not have any issue that is clear in the court records to say, I do not want this person to represent me. So there was a supposed relationship between the two. And we are here now saying it looks like they used to have a client and attorney relationship.
It will just quickly, the issue of the court having to ultimately decide on this aspect, when you look at what he's told the court and what it has to deal with now, he's raised his hand, nobody listened to him. It seems to me that that's also another aspect that the state may want to pursue.
Yeah, and I think that's why Baloyi has been leading this evidence. I think he's waiting for Ntanzi to say, you know what, call him Giaco, But I don't think that's going to happen. But during Ntanzi's evidence in chief, he did say that on his first appearance, he didn't raise his hand, right? And then he also says that when he was raising his hand, there was an issue with the magistrate that was listening to his bail hearing or his matter. But when they changed the magistrate and now it was a black lady, that lady was able to listen to him. So Ntanzi has a lot of, I'm the victim here. This was done to me by this person or this person, But at the end of the day, it doesn't make sense that the same person, even when he is fired or no longer has a mandate, they read out his reasons for no longer representing Ntanzi anymore or Mjiako. And nothing is said about the fact that, hey, I don't have a mandate. It is read to Ntanzi. Ntanzi is listening to this, and he doesn't say anything and say, hey, no, actually, the reason why I've asked this person not to represent me anymore is because he never had a mandate. I never actually hired him. He doesn't say those things. So which court is actually going to believe at this point that, no, actually, you know what? Somebody out there sent Mjiyako, and it had nothing to do with anyone from Ntanzi's camp. It's impossible.
Yeah. All right. So it's going to be quite interesting looking at how he decides to go about tackling that piece of evidence. Whether or not he's going to call in Ntokozo Mjiyako is something that we all wait to see. Let's take a quick ad break. More of the evidence when we return. All right, so this week we also saw tensions flare up amid disputes in the matter as the state was taking Bongani Ntanzi through the evidence regarding the disputed lawyer Ntokozo Mjiyako. A dispute arose over the name of a legal practitioner associated with the firm. Take a look.
If it was Mrs. Chia, how would she have known that you have to appear in court on the 29th of June 2020?
The appearance of the 29th of June 2020, Exhibit RR, the person representing accused number 1 is Miss Machie. It's not Miss Chia.
I mean, we're splitting hairs. There was only one lady. You can see it's just a typographical error.
No, but it must be read as...
No, come on, please. It's just a typographical error.
Who says so?
You see, hello, wait. I've got a bit of intelligence. Yes. Just read the letterhead of the Mjiyakos, the surname of that lady. God. Jesus.
It's Mr. Dineo Chia, right? TJIA.
Yeah, TJIA. I take it we are all blacks. TJIA. And on the other one, you say it's Machie. Is that not so?
Yes.
Machie.
Yes.
From the hand script.
Yes.
Right.
Yes, but...
So that's why I'm saying...
But my lord, you know...
Okay, I'm wrong then.
No, you are not wrong.
I'm
addressing something else. I'm addressing something else, my lord. My lord, when I stand up here, and I've always said it, and I'm going to be very calm with it, I'm saying the record must be read as is. Here it's Miss Machie. There may be a Miss Chia and Miss Machie. There may be Kwena and Makwena. They are not the same persons.
Yeah, that's why I'm saying.
But importantly, my lord makes this remark. At least I've got a bit of intelligence. So Ramsepili does not have.
No, it's because
no. That's what the court is saying.
For 35 years I was an attorney.
I've got 20 years now.
Yeah, right.
20 years as an attorney as well.
Just wait, man. Let me give you some bit of experience.
Another dispute arose, and still on the issues of Mjiyako.
Mr. Mjiyako is again on record. Are you also saying that on this occasion you did not give him instructions?
No, objection, madam. That's exactly what Mr. Ramusipili is saying, that the state is misleading the court because it has not read the whole information that is contained in this record. On the 3rd of August, 2020, this is what is recorded here. Adjourned until the 17th of August, 2020, accused absent due to COVID in absentia. So how would have Mr. Ntanzi knew that Mr. Mjiyako was there when he was not at court? We requested the state to be very sincere and be very honest with this court, my lord. I said yesterday on numerous occasions that we owe this court a duty, uberima ifide. Uberima ifide simply means of the utmost good faith. We need to be sincere to this court because at the end of it all, the decision that the court is going to take, to a larger extent, it depends on what we are telling this court as counsels, my lord. Now, if we are misleading this court, then there is just but that little probability that the court's decision will also be based on what we've been saying, which has been misleading to this. We implore the state to be very sincere with this court.
I think it's too strong to say it's misleading. He could be making a mistake. But when he says,
how does he make a mistake when he's got a document in his possession?
This is the problem. Okay, you argue with a judge.
Thank you, my lord.
Yeah, this is what happens to blacks. You argue with a judge.
Excuse me, my lord.
This is what happens to blacks.
To blacks.
Yeah, to blacks like me.
Yes.
Yeah.
Thank
You know
you.
what? This thing of saying it's misleading. This gentleman could be making a mistake. When you say it's misleading, it means he is lying. Like
He's intentionally doing it,
It means
my
he's
lord.
lying like my brother Madlanga put it the other day.
Yes, my lord.
Right.
But
Are
my
you
lord-
lying, sir?
No, my lord, I'm not done. But how can he say? How can the court say that he could be making a mistake when he's got a document in his position?
Okay, fine, fine.
He is reading it.
Let's ask him. Let's ask him.
All right, I'm still joined by my panelists here in studio, Itumugwena, as well as Subongiseni Gunene and Melusi Kulu. Thank you very much for staying with us. Itu, issues of court decorum, once again, are coming up. Let's talk about that and what your assessment of, what we've just played is for you.
Ngwana ko gae, ska peinelwa, relaxa. I understand, everybody is in their fields because things are not going their way. I mean, that was a simple objection that Mr. Ramsipilo was raising, but the way he came with that objection, like it was just a lot, the disrespect towards the judge, the court, the decorum itself, it's honestly quite telling. And I think Judge Ratha is one judge that has experienced quite a bit of this. And I think because there's so many of them there, right? There's Mr. Ramsipile, there's Mr. Ngumalo, there's Mnisi, and there's also Mshololo. There's a lot of them, and they're all coming at the same time. So handling them would prove to be quite difficult. But sometimes I question, is this really the best way to handle situation? Because most of the time he keeps quiet. He doesn't say anything. And then when it actually happens, everybody seems to think that it's normal. But when you look at other courts, the respect, the decorum, it's so different in Judge Ratha's courts. But I think this week he said something, he spoke up, he said, I experience these things because I'm the type of person that I am, and it will continue happening like that because the professionalism is not there. Nobody's holding themselves accountable and saying, actually, I cannot speak to a judge like this. Let me stop here. Yes, he's hurt my frustration. He's hurt my objection. Let me stop here. Why do I continue now and get emotional? And I mean, why is Mr. Ramsipile telling us about his 20-year experience? Initially, he said he's got 100 years experience. Now he's got 20 years experience. Now he's competing with the judge. Where is the respect for the courts?
So, Bongsen, I want to bring you in there because I saw there was a lot of reaction to also what the judge said during the week in relation to these things happen to blacks like me. So those black comments, again, seemingly rubbing some people in some quarters the wrong way. Do you think that when we look at these things happen, we look at them in context and listen to hear what is actually being said? And do you think there's room for such comments in the courtroom?
Hey, Linda, you're asking another question. Well, I've observed what happened during this week, and both sides, from the judge side as well as the legal practitioners. Well, I can't say that the judge was correct, and I can't say that the practitioner was correct, because when there is an objection that has been raised by a legal practitioner, what is expected is that the court is going to make a ruling, is not going to amplify the objection. And you see, because the issue was about transcripts that were read, and the transcript that were read from the previous court, and which then the defense were saying that these transcripts are read halfly, they are not read correctly, so that the accused can comment on something that has been put on record correctly. So then now the adjudication between the judge and the attorneys, well, it was not something that is warranted and good for the public and for the court at all, because what is expected is that there must be a level of respect and collegial, both sides, from the judge as well as the attorneys. The fact that somebody is presiding on a matter then does not mean that he can speak anyhow to the litigant, and as well as the litigant does not have to speak anyhow to the judge. There must be a level of respect on the both sides. That's how it has to happen in court.
Yeah, and what are your reflections, Melusi? Because some may say we hold judges to a higher standard, and that's why he always gets backlash so much. Do you think that should be a widely held view, and should actually be why we hold judges to a higher standard?
Hi, Linda. I think we always come to this when it comes to the judge. But I think at the same time, I also agree with Mr. Gnene. What is important is that they must be able to listen to each other. So we hold the judge in a high regard and expect him at least to respect and give, that level of respect to the practitioners. But as well, we expect the practitioners to respect the judge. This is very important. That the decorum in court is expected to be in a very peaceful manner and professional manner.
So, let me come back to you. I mean, because you and Melusi are legal practitioners, I mean, the kind of tone and the kind of language used on the judge, I've already spoken to Melusi about holding a judge to a higher standard, but also legal practitioners also need to be held accountable to some certain degree in terms of how they carry themselves in court and the language that they also use.
Well, language that has to be used in court has to be that of professional, and the attorney has to be professional, an advocate or prosecutor, however, right? As well as the judge. Being a judge does not mean that now you can just speak anyhow and you can just throw tantrums anyhow just because you are presiding over the matter. The only thing that makes you different to those legal practitioners who are there in court is that you are going to preside over the matter. Other than that, the level of professionalism has to be reciprocated on both parties. That is what is expected. Then tone, at some point, it happens that there will be a high level of tone because of maybe some exchange of words between practitioners other than the judge. Then it does happen, but nonetheless, it has to be in a level of professionalism.
From a person that's watching this case, as an ordinary member of society, how should we be interpreting what we see play out in court? You've followed this case for a very long time, so you are pretty much privy to the nitty-gritties and how decorum has previously degenerated in the courtroom.
Yeah, I think the attorneys need to do better towards the court. That is how respect is going to be followed. That is why the accused are also answering the way they are answering to the NPA. The disrespect has been there to the NPA, to the court. Nobody cares much, so you're going to see it in the proceedings. At least that's what I'm seeing from sitting at home, that there is no level of respect for the decorum or for the profession at all. That's why we have these issues.
If I hear you correctly, you're raising the issue of witnesses. Are you saying this then sets the tone for witnesses who can come and be disrespectful not only to the judge but also to the legal practitioners?
Absolutely, Mnisi, that's exactly what I'm saying. We've seen it. There was a witness that has come before and said that, my lord, you know what, I feel like I'm being disrespected here. And that was when he was getting cross-examined by the late Mr. Ngomezulu. The witness literally said that I can't take this anymore. And we've seen how Advocate Mnisi cross-examines witness and tells them that I'm in charge here. I'm going to tell you when to keep quiet and when to answer because I'm in charge. You are mine for now. Things like that honestly makes us feel uncomfortable. There should be more respect coming from the attorneys.
And it brings me, Sibongiseni, to the issue around witnesses. In fact, it raises quite an important point. I mean, when we look at how witnesses have behaved in this courtroom throughout the proceedings, some may say, for example, the likes of Gininda, they say he also does not answer questions. They find the way that he answers questions quite problematic. Others would view certain responses from defense witnesses as threatening. What is your assessment of how witnesses have behaved in this trial?
Well, there is a problem on a number of witnesses who have been behaving somehow, and which we can name them. Zandi also was in court, and there was no level of respect to the legal practitioners there. To be precise, Mshololo, he didn't want to respect Mshololo during cross-examination, and for whatsoever reason, then we don't know. Then, well, insofar as Brigadier Gininda, I think maybe a question when it's being posed, the problem is when you ask an open-ended question, allowing the witness to explain. So then you then lost control as to how the witness is going to answer because you have asked a question which is open-ended, which gives some explanation. That is why you had some explanation from Gininda, and then you get irritated as a legal practitioner because you're looking for an answer that maybe is yes or no, or a short answer. But however, then you invited the witness by asking an open-ended question. Maybe also those things maybe they played a role as to why the witness was explaining further and then now starting to fight with the counsel. But then that is what has been happening there. There's nothing I can say about it.
Yeah, and Kulu, just quickly, we've run out of time. The last point that I had raised with Sibongiseni is the issue of some witnesses, said to be leveling threats against legal practitioners in the courtroom. Would you say that that also is a contributing factor to some of the problems that we're seeing?
Yes, it could be a contributing factor, but I think the court in that instance has to be the one that, gives order or provides a direction to control the witnesses if they do give threats to legal practitioners so that the professionalism that we're talking about is maintained.
All right, so let's take a quick ad break. That's Melissa Kulu there responding to us. After the break, we wrap it up. So we'll see you after this. All right, so let's pick up on what is left to do. I want us to talk about, the turning to the affidavits, right, which is something that the state is seemingly moving to. And I'm sure a lot of people will be happy to know that week 4 we'll be getting into perhaps something new. Yeah.
Yeah, very excited for that aspect, but I'm quite concerned because we all watched that bail hearing and the inconsistencies in that affidavit. I mean, Titi Tobani is the one who did the bail hearing, and then Rambusipilo was there for the judgment. So a lot of things are going to be confirmed, especially the inconsistencies. The contradictions are going to be confirmed. We are looking forward to that new aspect of the case now. We're looking forward to that, and we can't wait to hear how, that affidavit or that hearing, Gininda said it so loudly to say that Ntanzi is lying, and if we can see some of the things that he has mentioned now in the trial and that he had mentioned in the bail, which he has abandoned altogether, it's going to be something to look forward to.
Yeah, and I guess, Sibongiseni, the question around bail proceedings being a part of the main trial and the legalities around that also arise.
That's correct, Linda, and it's very interesting because we know very well that on the first appearance, Ratha Mokgoatlheng says anyone who wants to apply for bail can apply for bail now, right? And nonetheless, even during the trial within a trial, there were some points wherein there was an argument that arose between the state and the defense about the proceedings of the lower courts being transported to this matter. And Ratha disagreed with the state as well as the defense that he is of opinion that the proceeding from the lower courts, they are null and void. They could not be used in this court. And it's quite interesting if that thing is going to arise maybe on Monday. As you remember that this court has made a ruling about these proceedings. In fact, he has made some remarks that the proceedings from the lower courts are null and void. But nonetheless, as far as we understand, he was nullifying it because he says they were interlinked with the proceedings of Maungela, who then presided on this matter before. We don't know that what is going to happen on Monday. If the defense, they want to bring that type of argument to say, but you said these proceedings and then they could not be forming part of this. And you also said that if anyone who wants to apply for bail can apply for bail at this stage. We will see what is going to happen on Monday. But nonetheless, in terms of the law, there's absolutely nothing wrong for that proceedings to be there.
And let me come to you, Melusi. Sibongiseni raising the issue of the proceedings of a lower court being a part of the main trial, and raising the issue of how they were interlinked with the proceedings before Maumela J. And what's interesting is that I've covered quite a number of bail applications, and you would often hear an accused person being warned that whatever that they say in that bail application can and may be used against them during the main trial.
Yes, Linda, just to be brief, whatever you say in bail or in a bail application will be used during the trial if there's a need. So if there's something that is contradicting or that supports your case, it will be used. It will be strange for a judge to say what was stated in a lower court could not be used. So it will be interesting to see how that argument will be heard or will be determined. So I'm looking forward to see what the judge will say if the defense says, but you refuse to deal with this some time back. Why are you now dealing with it? So as Mr. Gnene says, let's see what will happen on Monday.
All right, it'll be quite interesting to see what happens on Monday, knowing Judge Ratha Mokgoatlheng, he may come armed with the law, to tell us exactly what it means for what is about to happen. But of course, you'd recall at the beginning of the show, we did ask you to vote on our poll question, which we were running on social media. Let's take a look at those results that came through. And the question was, is it at this point necessary for Bongani Ntanzi to then call an expert witness, in line with the fact that he's disputing cell phone and photographic evidence? 81% of you say yes, 6% are saying no, he's doing just fine, and 13% saying, well, the ship has sailed. So those are your votes that have come through via social media. And you do know that because this week we were not live, we had to run them through our social media platforms. And that's what you've had to say on those platforms. We'll be back again next week with a wrap of the upcoming week's evidence. So you and I will see each other again at that point. Until then, bye-bye.